we come in, sir?
Come in.
Thank you, sir.
Please sit.
Thank you, sir. Good afternoon, sir.
Good afternoon. So please introduce yourself.
Sir, my name is SuSMITA Sharma. I belong to town Sundarnagar of district Mandi, and I have done my schooling from St. Mary's School, Sundarnagar. Thereafter, I did my graduation in law, BLB honors from ULS Shimla. Sir, currently I have been posted as an assistant legal aid defense counsel at DLSA Mandi. And sir, my hobbies include singing.
Okay. So what is the meaning of your name?
So the name of my meaning is a girl with a beautiful smile.
Okay. So why did you choose law only as your career?
Sir, in my class 10th only, I decided that I would pursue law because I thought at that time I thought that law was something different. Plus, it was professional because all of my friends talked of doing engineering and going into medical. But I was of different opinion that I should do something different. It was only this understanding I had at that mind. There was no particular guidance, but it was my decision only to do something different and something professional.
Okay.
Yes, sir.
Who is the Chief Justice of India at present?
Sir, His Honorable Mr. Justice D.Y. Chandrachud, sir.
Okay. How many judges are there in the Supreme Court at present?
Sir, it's 34 at present, sir. It's working with its full strength.
Okay. Who is the current President of India?
Sir, Srimati Draupadi Murmuji is our Honorable President.
Who was the first woman judge of Supreme Court?
Sir, she's Fatima Bibi.
Okay. When the Constitution of India was adopted?
Sir, it was adopted and enacted on 26th of January 1950, sir.
What is the difference between Article 226 and 32 of Indian Constitution?
Though both the articles deal with the writ jurisdiction respectively, but the difference, Article 226 deals with the writ jurisdiction of the High Court, sir, and Article 32 deals with the writ jurisdiction of Supreme Court, and sir, there is also a difference in their scope.
Okay. Tell me, what is the anticipatory bail?
Sir, anticipatory bail basically means a bail in anticipation of arrest. It is contained in section 438 of the CRPC, sir.
Okay. Then does res judicata apply to bail application?
So res judicata doesn't apply on changed circumstances. So in that case, it doesn't apply on bail because there can be changed circumstances. So if it would apply, then we would be barred from filing bail again. So that it doesn't apply, sir.
Just tell me, can accused become a witness in his own case?
Yes, sir. Accused can become a witness in his own case as per section 315 of the Code of Criminal Procedure.
Okay, all right. Who can grant pardon to co-accused?
So grant of pardon has been talked about in 305, 306, 307 of CRPC. The magistrate can also grant a pardon as well as the court of session can also grant a pardon under section 307.
What is trial in camera?
So in camera trials, they are basically proceedings. In camera proceedings means they are not conducted in the open court. It is mostly done in the case of sexual offense cases, sir, so that the victim and the accused person do not get in contact with each other and the confidentiality of the victim is also maintained.
हिंदू मैरिज एक्ट के अंदर जो प्रोसीडिंग होती है वो इन कैमरा हो सकती है कि नहीं?
Sir, in camera हो सकती हैं, but generally they are not carried out in camera, but they can be, sir.
Okay. Then what is the evidentiary value of confession?
Sir, the confession holds a lot of evidentiary value. It's a substantive piece of evidence, sir.
Okay. What is primary evidence?
Sir, primary evidence has been defined in the Indian Evidence Act. Actually, it's section 61. Sir, I'm not able to exactly recall the section, but it is the document itself which is produced for the inspection of the court. That is called the primary document.
Okay. Who is called a hostile witness?
Sir, a hostile witness is not necessarily a false witness, but he is such a witness who does not depose in accordance with the wishes of the party who has sponsored him, sir. That is a hostile witness.
Okay. Tell me, can a witness be compelled to answer a question which may entrap him in an offense?
So he can be compelled to answer a question. Yes, sir.
Where it is given?
So, section, I'm not exactly able to recall. It's somewhere around 133 or 132, sir. I'm not able to exactly recall the section, but there is a provision in the Evidence Act regarding this.
Okay. Will the principle of res judicata apply to the habeas corpus?
No, sir. The writ of habeas, the res judicata doesn't apply to habeas corpus, sir. There is a particular reason behind this, sir. So
Okay.
should I?
Yes, please.
Sir, habeas the res judicata cannot apply to the writ of habeas corpus because of the very nature of the writ, sir. So this is the reason.
Okay. Just tell me, suppose there is a government. Government has violated the civil right of a private person. ठीक है? Then मान लो suppose अब जो private person है, he want to file a suit against the government. What is the requirement and what is the precondition before filing the suit?
Right, sir. Sir, such type of suits have been dealt under the Code of Civil Procedure, and there are proper provisions for this thing. That if a suit has to be filed against the government, what procedure has to be followed? It is given under Section 80, read with Order 27 of the Code of Civil Procedure, sir. In that case, we have to serve a notice upon the government. Uh, After that, a particular notice of there's a statutory period, sir. After that, the suit can be instituted against the government.
Is this rule applicable upon semi-government also?
Sir, I'm not aware of this.
Okay. मान लो
Regarding this,
ओके मान लो सपोज फॉर एग्जांपल पीडब्ल्यूडी डिपार्टमेंट है और पीडब्ल्यूडी डिपार्टमेंट के जो एक्सन है एक्सन जो होते हैं एसडीओ एक्सन जो ऑफिसर है उन्होंने किसी का वायलेशन किया किसी प्राइवेट पर्सन का राइट वायलेट किया ब्रीच किया उनके लिए भी सेम रूल रहेगा और वायलेशन अंडर द ऑफिशियल कैपेसिटी हेलो आई एम ऑडिबल Okay. What is your answer?
sir, would you please repeat the question?
ओके मान लो सपोज फॉर एग्जांपल कोई गवर्नमेंट ऑफिसर है पब्लिक सर्वेंट है अगर कोई वायलेशन करता है सिविल लीगल राइट वायलेट करता है किसी पर्सन का तो उस पब्लिक सर्वेंट के लिए भी क्या सेम रूल एप्लीकेबल होगा इज द जो नोटिस रिक्वायरमेंट है वो सेम रहेगी एज गवर्नमेंट
सर, अगर वो अपनी ऑफिशियल कैपेसिटी में कोई एक्ट करता है तो वो रिक्वायरमेंट रहेगी सर उस केस में, बट इफ इन प्राइवेट कैपेसिटी देन इट वुड नॉट बी.
Okay, yes. Suppose if immovable property is situated in jurisdiction of different courts, like one property situated in Shimla, another property situated in Mandi, so where should the suit be instituted?
In that case, the suit can be instituted in any of the courts where the property of the subject matter is situated by virtue of Section 17 of the Code of Civil Procedure, sir.
Okay. What is an ex parte decree?
Sir, ex parte decree, basically, it is a decree in absentia. When a particular party, like a defendant, has not come into the court despite service of the summons, and he has not appeared when the suit was called on for hearing, in that case, sir, ex parte decree is passed.
Okay. Tell me, can a judge also pronounce a judgment which has been written by other judge but not pronounced?
Yes, sir. So there are provisions regarding this, that yes, a judge can pronounce a judgment written by his predecessor judge.
Okay, what is cross objection and who can file cross objection in appeal under CPC?
Sorry, sir, I'm not able to recall the provisions regarding this right now.
Okay, right. Then tell me, who are the members of Juvenile Justice Board?
So, Juvenile Justice Board, it consists of the principal magistrate, that is the not below the rank of Chief Judicial Magistrate, sir, and it includes the prosecutor. And there are, sir, I not exactly recall the number of members, but some are social workers of the locality. A woman has. I'm not able to exactly recall, sir. I need to refresh my knowledge on this.
Uh, what is the full form of POCSO?
The POCSO.
POCSO.
Okay, sir. Sir, it's prevention of sexual offences against children.
Okay. Have you heard about skin to skin contact case?
Yes, sir. So I have heard about it.
Please name बताएं.
सर एग्जैक्टली मैं रिकॉल नहीं कर पा रही नाम, बट इसको क्योंकि मोस्ट कॉमनली स्किन टू स्किन कॉन्टैक्ट जजमेंट के नाम से जाना जाता है, तो मेरे को इसका एग्जैक्टली केस नहीं याद आ रहा सर.
Okay. Can husband file a case against wife under DV Act?
Sir, DV Act is entirely women centric. It's not applicable to in the case which you asked about. Not applicable, sir.
Okay. How many relief are available to the aggrieved person under DV Act?
The number of reliefs, or I should name them because I cannot exactly recall the number, but I know the name, sir.
Please name.
Sir, there is a protection orders, the monetary reliefs, the residence orders, sir, custody and compensation. So these are the orders which are available to a woman.
Okay. What is the legal aid scheme?
So legal aid scheme, its origin lies in the Constitution of India, that Article 39A, Article 22, Clause 1, as well as Article 14 of the Constitution. By a combined reading of these articles, they say that justice should be provided to each and every individual, irrespective of any bar, whether it be poverty, whether it be gender. So legal aid scheme, so basically it has the object to provide free legal aid, that justice should not be denied to any individual. All should have access to justice, sir. This is the major aim of the legal aid, sir.
Okay. Just tell me, suppose you are a judge, you were insulted in the open court. What are the remedies available to you?
Sir, in that case, contempt of court proceedings can also be initiated, and the complaint can also be made to the concerned bar council. If it was done by an advocate. If it was done by any other person XYZ, like a witness or a party to the suit, sir, being a magistrate, I would initiate contempt proceedings against that person.
Okay. Just tell me, can additional accused be summoned after delivering judgment with respect to co-accused?
Sir, not it cannot he cannot or she cannot be summoned after the pronouncement of judgment. There is a clear bar, and there is a recent judgment, sir, regarding this, in 2000. Sir, I'm not able to exactly recall the name of the judgment, but this thing was pronounced in that after the pronouncement of judgment, it they cannot be added, sir.
Okay. Just tell me, suppose a senior police officer demand detention of the accused in police custody after the expiry of first 15 days in a case where some more serious offense has been discovered to be committed by an accused in the same transaction. Whether he is justified in asking for more police custody?
Sir, the police custody was granted in the first 15 days. Full 15 days was granted
Yes,
in the
मान लो
case which you
सपोज
are
फॉर
talking.
एग्जांपल कोई न्यू ऑफेंस 15 डेज में कोई कस्टडी नहीं मांगी, 15 डेज ओवर, आफ्टर 15 डेज क्या पुलिस ऑफिसर डिमांड कर सकता है पुलिस कस्टडी का?
See, Section 167 talks about that the police custody can be granted 15 days in a whole. Earlier, the situation was that in the first 15 days only, the police custody could be granted. But, sir, there is a recent judgment in 2023, Balaji sentence judgment, in which it has been clarified that even after the lapse of first 15 days, अगर उस दौरान नहीं दी गई पुलिस custody, तो सर उसके बाद भी वो grant की जा सकती है. तो सर, it can be granted and by virtue of the Balaji sentence judgment.
Okay. Is compliance of notice of section 41A of the CRPC is mandatory?
Yes, sir. So compliance of notice is mandatory, sir.
Mandatory. Okay. Then tell me whether victim has the right to be heard at the time of granting of bail.
Sir, when the bail has to be granted, whenever it is filed in the court, the prosecution is given an opportunity to file a reply. So in that case, because the prosecution is representing the victim, the state is representing the victim. So in that sense, we can say that she has a right to be heard in that sense because she's being represented by somebody, the state. So they file a reply only after that consideration is done, sir, and the bail.
Okay.
Yes, sir.
Tell me whether an accused is entitled to statutory bail under section 167 clause 2 of CRPC on the ground that cognizance has not been taken before the expiry of 60 or 90 days as per the case from date of remand.
Sir, the right of default bail arises in favor of a person if the charge sheet has not been filed before after the expiry of 60 or 90 days, as the case may be. So, because the judge will take the cognizance only when the charge sheet is being filed. So, in that case, if the charge sheet is not filed, then the right of default bail arises after the lapse of the statutory periods in Section 167 Clause 2, sir.
Okay. Tell me whether the sentence imposed against the same accused by two different courts in two different trials should run concurrently or consecutively.
The two different judges have given the sentence.
In
Two different
trials.
courts.
In different trials. Sentence क्या consecutively run होगी या फिर concurrently?
Sir, same case में तो consecutive is the rule and concurrent is an exception. अगर जज बताए कि वो concurrently चलेगा, अगर वो expressly कहे तो ही concurrently चलता है, otherwise consecutive चलता है. But sir, वो same case में होता है, मतलब. But sir, I'm not aware of the different punishments given by different courts.
Tell me whether the bail granted under section 167 clause 2 of CRPC can be cancelled after the presentation of the charge sheet. If yes, on what ground and circumstances?
Sir, I'm not aware of this. I'm not able to recall this.
Okay. Next question. Can session court grant anticipatory bail in cases like offense committed in Delhi and arrest apprehended in Punjab?
So there is a recent judgment regarding this that yes, it is possible, but I'm not able to recall the name of the judgment. But yes, sir, it is possible as per the recent pronouncement of the Supreme Court.
Okay. Tell me, can accused seek default bail if charge sheet filed is incompleted?
Sir, sorry, I'm not aware of this right now. I'm not able to recall actually.
Okay. Tell me, what is void marriage?
It's a void marriage.
Yes, void
Okay,
marriage.
sir. Yes, sir. So there are certain circumstances given in Section 5 of the Hindu Marriage Act, which are actually the conditions of a valid Hindu marriage. There are certain conditions by the non-compliance of which the marriage becomes void, and it has been defined under Section 11 of the Hindu Marriage Act. Like a person is sapinda, is in a prohibited relationship, or in case of bigamy, the marriage becomes void, sir. It's a nullity in the eyes of law.
Okay. Can children of the void marriage treated as co-partner by birth under in Hindu family, in Hindu joint family?
Sir, sir, they cannot be उनको co-partner तो नहीं माना जा सकता, but sir, they have a right in their parents' property. Not they cannot be considered as co-partners in the ancestral property. सर उनका कोई right नहीं होता है.
Okay. What property may be transferred under TPA?
So the general rule is that every kind of property can be transferred. There is a popular maxim. So सेक्शन 6 में दिया गया है, मतलब कि हर तरह की प्रॉपर्टी ट्रांसफर की जा सकती है, लेकिन कुछ ऐसी प्रॉपर्टीज हैं जिनको हम ट्रांसफर नहीं कर सकते हैं, उनकी लिस्ट दी हुई है सर सेक्शन 6 में. सो दैट वे.
क्या मूवेबल प्रॉपर्टी भी ट्रांसफर होती है टीपीए में?
Sir, movable property is not a subject matter of the Transfer of Property Act. It is separately dealt with under Sales of Goods Act, sir.
ओके. गिफ्ट में हम इमूवेबल प्रॉपर्टी होती है कि मूवेबल भी होती है गिफ्ट? टीपीए के अंदर गिफ्ट दिया है, तो गिफ्ट में हम सिर्फ इमूवेबल प्रॉपर्टी ट्रांसफर करते हैं कि मूवेबल भी करते हैं?
Sir, immovable property, sir. Sir, I'm not able to. I may be wrong, but as far as I can recall, it is immovable property, sir.
Okay. Okay. What is an actionable claim?
Sir, actionable claim, it has also been defined in the Transfer of Property Act, sir. It's basically unsecured money debt and interest in movable property, not in the possession, actual or constructive of the person. And these are such claims which are considered actionable by the court of law, enforceable by the court of law.
Okay. What is void agreement?
Yes, sir. So, void agreement is such an agreement which has no existence in the eyes of law. They are nullity, they are void ab initio, and the category of void agreements has been given, particularly stated in the Indian Contract Act itself.
Okay. Tell me how many types of mortgage under TPA?
Yes, sir. So, one is simple mortgage, so mortgage by conditional sale, the usufructuary mortgage, English mortgage, mortgage by deposit of title deeds, and sir anomalous mortgage. So only these are the categories which are given under the TPA.
Okay. So tell me, मान लो सपोज फॉर एग्जांपल ए अक्यूज्ड है, हमने ए अक्यूज का नार्को टेस्ट एनालिसिस करवाया, ठीक है, वॉलेंटरली उसने कंसेंट दी. अब जो इंफॉर्मेशन रिवील हुआ फ्रॉम द टेस्ट, जब टेस्ट हुआ, कंडक्ट हुआ, उसके जो इंफॉर्मेशन रिवील हुआ, क्या वो इंफॉर्मेशन हम यूज कर सकते हैं एज एन एविडेंस?
सर जो नार्को एनालिसिस टेस्ट है सर, इसके ऊपर सेल्वी वर्सेस स्टेट ऑफ कर्नाटका की जजमेंट, लैंडमार्क जजमेंट है, एंड इट स्टेट्स दैट सच टेस्ट्स आर अगेंस्ट द ethos of the constitution. They are not at all valid. So in that case, because it amounts to testimonial compulsion, sir.
नहीं,
Sir,
अगर वो
so it
वॉलेंटरली
cannot be
करता है,
used.
वॉलेंटरली करता है।
So in that case it might be used because उसके विल के अगेंस्ट करें सर तो नहीं हो सकता यूज। यस सर।
Whether the statement recorded by the investigating officer under NDPS Act treated as a confession?
Sir, there was a judgment of Tufan Singh in the year 2020, but sir, it will be hit by section 25 of the Indian Evidence Act.
Okay. Are the statement of the witness made to police required to be signed by the witness?
No sir, such statements are not at all signed.
Okay. What is the stereotyping, gender stereotyping?
सर जेंडर स्टीरियोटाइपिंग एक परसेप्शन है हमारी सोसाइटी की कि जो पर्टिकुलर जेंडर्स है, फॉर एग्जांपल मेल इज एसोसिएटेड विद सर्टेन रोल्स एंड फीमेल इज एसोसिएटेड विद सर्टेन रोल्स। तो सर एक परसेप्शन बन गई है, समाज ने एक धारणा अपने दिमाग में बना ली है कि अगर मेल है तो वो यही काम करेगा, अगर फीमेल है तो यही काम करेगी, और इससे जेंडर डिस्पैरिटी आती है। दिस इज द मेजर रीजन बिहाइंड द जेंडर डिस्पैरिटी which prevails in our society, sir.
Is there any recent judgment on this point?
Yes, sir. So there's a very recent pronouncement of the Supreme Court, Aparna Bhatt versus State of MP, which very categorically the Supreme Court talked about gender stereotyping.
Okay. Now you see, the DV Act use the word nature of marriage. ठीक है, so then what do you mean by nature of marriage?
So nature of marriage, so like relationship in nature of marriage.
Yes, yes. Domestic relationship definition अगर आपने देखा होगा तो उसमें word use हुआ है nature of marriage. So what do you mean by nature of marriage?
So it specifically talks about the live-in relationships. Actually, it was made for that purpose कि अगर कोई couple बहुत समय से साथ में रह रहे हैं और उनका relationship, though they are not married, but it is in the relationship of a marriage, like a relationship of marriage. So उस sense में ये उसका ambit को broad करने के लिए ये term include की गई थी sir इस definition में।
Okay. What is marital rape?
Sir, this topic was recently in discussion, and marital rape का issue sir, अगर एक husband जो है wife की consent के बिना उसके साथ शारीरिक संबंध बनाता है तो उसको marital rape की definition में लाया जा रहा था sir, and it's a very there has been very controversy regarding this, but yet the parliament and the Supreme Court have tried to remain silent on this topic till now sir.
Okay. आपने निपुण सक्सेना वर्सेस यूनियन ऑफ इंडिया केस सुना होगा। इस निपुण सक्सेना यूनियन ऑफ इंडिया में क्या हेल्ड हुआ था?
Sir, Nipun Saxena versus Union of India, as far as I can recall it, it's regarding sexual offences का कुछ guidelines आई थी सर इसमें, but मैं exactly recall नहीं कर पा रही कि इसमें क्या held हुआ था सर।
Okay. What is constructive res judicata?
So constructive res judicata, it's basically referred to in explanation 4 of section 11 of the Code of Civil Procedure, and it's referred to as artificial form of res judicata कि अगर might and ought का इसमें रहता है कि अगर आप कोई ground ऐसा था जो it had might and ought to have been raised तो उसको constructive res judicata की category में ला दिया जाता है, and उसका same ही effect है सर जो actual res judicata का है।
Okay. Just tell me whether the content of memory card, pen drive, CD, submitted to the court along with the challan, police report can be treated as document?
Yes, sir. So they can be treated as document. There was a pronouncement of the Supreme Court in the year 2019, by which it was very clearly stated that these like CDs, pen drives are perfectly in the definition of term document. So it can be, sir.
Okay. Can anticipatory bail granted under SC/ST Act?
Sir, I'm not able to exactly recall that whether it can be or cannot be. So I'm not sure on this, sir.
Okay. Last question. Can magistrate take cognizance in respect to the person against whom no challan has been filed?
Sir, cognizance can be taken on three things: the police report, the complaint, and suo moto on the information of the magistrate or from some other source. He can take cognizance. So for sir, अगर चालान फाइल नहीं हुआ है तो दो केसेस और भी बच जाते हैं, कंप्लेंट बचता है, सुओ मोटो बचता है. तो कॉग्निजेंस अगर उन पुलिस रिपोर्ट नहीं आई तो कंप्लेंट पे भी लिया जा सकता है कॉग्निजेंस, और सुओ मोटो भी लिया जा सकता है. तो आई वुड से दैट यस, कॉग्निजेंस कैन बी टेकन if the challan has not been put up by the police.
Just tell me, can the judicial magistrate pass an order of further investigation suo moto after taking cognizance?
Yes, sir. Sir, there was a judgment of Vinu Bhai, Hari Bhai Malviya versus State of Gujarat in the year 2019, whereby the Supreme Court very clearly stated that yes, by virtue of Section 173, subclause 8, the magistrate is fully empowered to order further investigation, even after the filing of the charge sheet, sir.
Okay. Whether an aggrieved person has right to claim that an offense be investigated by any particular agency like CBI of his choice?
No, sir. So, aggrieved person doesn't have a right. This was also clarified by the Supreme Court. I cannot exactly recall the judgment, but it was back in 1991 that the accused the aggrieved person doesn't have a right to call it to have the investigation done by a particular agency like CBI.
Okay. Just last, incest cases. What is incest cases?
So, incest.
Incest.
Sir, I'm not able to exactly recall, but I have studied about this. But abhi, sir, I'm not able to recall this at this moment.
It's okay. Then tell me why we select you for this post.
Sir, I have two reasons, very big reasons. Like I see my judicial officer, I see my becoming a judicial officer as a measure of self-satisfaction, as well as a satisfaction of my conscience. I believe it's my calling. And second, at the societal level, so this is at the individual level. And at the societal level, I see my becoming judicial officer as a symbol towards women empowerment. So that's why I should be chosen as a judicial officer, sir.
Okay. Thank you and all the best.
Thank you, sir.